Hi, everyone. Are you able to hear me? Hello?
Good afternoon. Yes, I'm hearing.
All right, good afternoon. So I'm just waiting on a few more persons to join, and then I will begin. All right, good afternoon again, everyone. Let me know if you're able to hear me still.
Yes, miss.
All right, beautiful. So my name is Sandrine Morris, and I will be your tutor for this afternoon. We will be focusing on paper 2 for the Cape Law Unit 1 exams. And that has 3 modules, so we may be here for a while. I won't have on my camera for the entire session because the bandwidth is low, and I will need to be able to deliver to you while sharing my screen. So I won't have on my camera for the entire session, and I hope that is fine. Additionally, I just want to lay down some ground rules. I would love everybody's mic to be muted. And if you want to say something, you can simply raise your hands, or you can type in the chat and I will respond so as to respect everybody else that is here and that is trying to listen and learn. Secondly, this is not a teaching session. This is a review session. You would have gone 9 months. Hold on, give me a second. Yes, so you would have gone 9 months in which you would have learned the different topics that are involved in the course. So I am not going to reteach what your teachers have already taught you. Additionally, it is not like the past 2 years. It has gone back to the original where to you. We know that we can focus on certain things on the basis that they came in the last 2 years and they might not come back this year, but you still are expected to study everything, and you just have to manage your time wisely and do your best. What they will do is probably give you 2 questions and you can choose one, which is how the papers have been for the past couple of years. But there is no guarantee that it's going to be specific to this topic. They did not release a broadsheet, and so I will not be able, for example, module 1, to teach you 8 topics in one day when I need to go through 3 modules. So it's a review session. What that means is that we will go through some past papers, we'll go through some questions that may, pick your brain a little bit so that I can assist you with it, so that I can show you how to answer and what would have been expected of the A student. You can ask some questions, you can get some answers, but I am not reteaching the course. That is not practical, it is impossible. So those are the ground rules. I just want you guys to understand that 3 modules, I am not planning to stay here until 10 o'clock, and I think you guys aren't planning to stay here until then either. So it's going to be a review session where we're mainly going to go through past paper questions. So that is it, and we will get into the course. Please let me know if you can see my screen.
Yes, miss.
Okay, beautiful. All right, so the objectives for today is that 1, at the end of the session, students should be able to explain briefly all the topics that have been discussed or reviewed in the session. You should understand the meaning of IROC, and I'm going to emphasize that because this is going to be your saving grace, especially for your crim question. You should be able to answer a problem question using the IROC method, and you should be able to answer a essay type question. Now, essay versus problem question. An essay question usually contains a topic, and the question, it may ask you to evaluate or discuss or explain, or elaborate on this topic, and you are expected to do so using legal principles. And I make that pretty clear because if you go into a law exam and you begin to write and you don't use legal principles, it becomes an English essay, or a common studies essay. So please ensure that when you see an essay question, you answer it and you use the legal principles. But it's not where it's asking you to write whether so-and-so is liable for this, no. If it says you should evaluate or discuss, it expects you to answer like you would have answered a normal essay, with the exception that you are now using legal principles. A problem question, however, is usually presented in the form of a scenario. So you will see Jack went to Mary and something happened between Jack and Mary, and Jack was drinking or something of the sort, and you'll see all of these problems coming out in one question. That is a problem question, and that is where you will be expected to use the IROC method. Now, what is IROC? IROC is issue, rule, I for issue, R for rule, A for analysis or application. They can be used interchangeably, and C for conclusion. Now, issues are the focus questions that you have found from the scenario. So, for example, you see where Jack went to a party, and in that party, he saw some girls, and he went for some juice, which was some fruit punch. Then he went for some alcohol. And then he got into his car and he drove off. While driving, he hit Mary. Now, you don't need to ask questions about why Jack went to the party, what happened with the girls. That is not a part of, that's not a focus question. That is not important. What you need to ask is about him driving while intoxicated. Those are where that's where the focus questions begin to come into play, because that's where the legal questions began to come into play, because the purpose of the problem question is to see how much you know about the law. So it's not for you to just come asking whether about everything that is in, because then you will have like 10, 15 questions and you won't have enough time to finish. What is the deal breaker in terms of a problem question is that you should be able to show the examiners that you are able to identify legal issues and match legal principles to those issues and analyze and conclude that. So when you see a scenario, look carefully at the scenario and try to pick out the legal questions, the questions which you know there is a rule that you can put towards it. So that is all I'm saying. And I hope you guys are listening properly, because we have seen cases where people, even here at university, people just take up a question and you just start asking a bag of stuff that is irrelevant, and you're not getting marks for those. You don't get marks for stuff that don't make any sense or stuff that's not applicable to a legal rule or to anything of the sort. It's a law exam. We're just trying to see how much you know about law and not necessarily how much you can talk. Analysis. This is where you will compare different legal opinions to your scenario in order to arrive at, rule. I think I missed a rule. So this is the law which is applicable to the focus question. So once you pick out your focus question, whatever that is, you will begin now to look at the rule that is applicable to it. And usually the rule is the law. So you will look at whether a statute is applicable to this. You will look at whether the Constitution is applicable to this. You will look at whether there are any cases that have set precedent for this. And that's what you discuss in your rule. So if a question is saying whether he's liable for manslaughter or whether he's liable for murder or anything of the sort, then you will begin to look at, the first thing you will think of is the offenses against the person's act, because that refers and speaks to murder. And then you will look at cases which speak to murder, and you will look at the decisions that are in those cases and whether it's applicable to this scenario. And if you're going to ask questions about defenses, then you mainly look at the statute again, you look at the cases, and you apply those to the rule. So whatever your question to the issue. So whatever your issue is, the rule that you're going to apply to it is the law that is applicable to it. So whether the statute or case law or the Constitution. Analysis. This is where you compare different legal opinions to your scenario in order to arrive at a conclusion. So you are, after you have found the issue and you have found the law that is applicable to it, you're going to now look at your scenario and see whether it applies or whether it doesn't apply here. And you're going to make that comparison, or you're going to make that contrast, and you're going to have a field day explaining all that is happening here and whether this can work or it cannot work. That is your analysis. And conclusion, this is where you will state the findings from your analysis. So if your focus question is whether he's liable for manslaughter, or let's put it another way, if your focus question, remember he was drinking and driving and he met in an accident where he, basically killed Mary. So your question is whether he's liable for murder. And then you go through the rules and you realize that the law and the cases here that you have looked at, and you put them into your analysis, and you see that, at the end of the day, the law and the cases say if this happened, it is more than likely manslaughter. After that issue, you're going to, and your rule and your application, you're going to put that, hey, there is a possibility that he's not liable for murder, but manslaughter. So that is your conclusion. That is your conclusion after that issue. But a problem question won't have one issue. It will have 3-4 issues. And so if you find that it is likely that he's not liable for murder, but he's liable for manslaughter, then you're going to have to ask another question about whether he's liable for manslaughter, and you're going to have to go through the process again. At the end of all of this, after you have done, for example, 4 issues and you have 4 conclusions for those 4 issues, you still have to have a general conclusion wrapping up everything. So in essence, what I'm saying is that if there are 4 issues in the question, you're going to have 5 conclusions. A conclusion after each issue and a general conclusion after you have finished the question, basically. So I hope you guys understand that. If there are any questions, you can ask now before I move on. Okay. All right, so module 1. Module 1, in this module, and I am putting some things that I think are important because I did not see them coming back a lot on recent papers. And I know that last year they did classification of law, and the year before I would have sent the topics in the group as to what they would have looked at and what I would not be looking at, because I don't think they're going to come back now. Or even if they come back, I don't think they're going to put back classification and the other topic that came in 2021 and the other topic that came in 2020. It's more than likely that they will put something else that have not been there for a while. So in this module, we will look briefly at about 3 of the topics, which is the different theories and meanings of law, the interrelationships of law and morality and religion, and sources of law. I won't look at all the sources. I'm mainly going to focus on precedent. I'm also going to look somewhat at the court structure, looking specifically at CCJ against the Privy Council. So module 1 question. I have here what the perfect essay should look like. Module 1 questions are usually essay questions. Module 3, usually problem questions. And module 2 might have a mix, sometimes essay, sometimes problem questions, sometimes both. Same for the crim law questions. Sometimes they'll give you straight problem questions, sometimes they'll give you both, where you see a 25 marks question and 10 marks associated with an essay part. You'll see an essay part of it that's worth 10 marks, and then you'll see a problem question part that's worth 15 marks. So I have here what the perfect essay would look like. Perfect essay means that the student should have a definition of key terms. So it cannot be that the question is asking just random here. I'm saying the question is asking about a book and you don't, give a definition of book. You have to define all the key terms that you see in the question. So that is the first thing that you should do once you start your essay. You should ensure that all parts of the question is answered. And I have seen where people make this mistake where you overlook, like I have here, Commonwealth Caribbean country. You go into an essay, you start writing everything you know. And this is called like a kitchen sink kind of mentality, where I don't really understand this. And I'm going to go in there and I'm going to write everything I know, and any cases I know. It may be an American case. I'm going to drop it on the paper and that's going to be it. And they have to give me a mark. No, they don't have to. If the question says you need to answer with reference to a Commonwealth Caribbean country, it means you need to answer with reference to a Commonwealth Caribbean country. If you're Jamaican, I would advise you use Jamaica as your reference. That's a I don't know if I should call it a cheat, but that's something we do. Like if you are from Jamaica, use Jamaica. If you're from Trinidad, you use Trinidad. You're from Barbados, you use Barbados, because guess what? This helps you because you know your legal system better than you know another country's legal system. But once it says Commonwealth Caribbean country, you need to start speaking about Commonwealth Caribbean countries. Because if you go in there, start writing cases and legislation and everything from everywhere else and don't include anything from a Commonwealth Caribbean country, you're gonna fail at people, or you're not going to get that one or that two that you so desire. So I advise you to read all parts of the question. Also, if the part says with reference to a decided case or or with reference to decided cases, you need to include cases, because if you go in there just writing statutes and no cases, you're not going to pass that exam because you did not answer the question. So always look at all parts of the question and what it is saying so that you can ensure that you answer the question. Look at the marks allocated to each part of the question. And I have here that you don't get marks for answering what is not there. Like you don't get marks because you go in there speaking about the role of the ombudsman when nothing asked about ombudsman and you ignore what is there. You don't get extra marks, for just putting in things that you think you want to put there. You get marks as they are allocated to the question. I also have that you don't get marks for writing a whole book. If the question says define positive law and it is 2 marks, you don't get extra marks because you wrote a whole book about positive law and what every theorist that ever lived said about positive law, because it's 2 marks. It literally just wants you to define it. So I want you guys, and this is also a way how you cope with time, right? Because I don't remember how much time you get to complete the question, but I know it's 3 modules and it's 3 questions. You must determine whether you want to spend 1.5 hours on one question, and then you only get, say you get full marks, say you get 25 marks for question 1, but the paper is, 25 for 3 questions, I think. So say you finish question 1 in full and you're good and you get 25 out of 25, but then you did not get enough time to finish or to even start the other 2 questions. I hope you do realize that you still fail the exam, even if you get A+ on 1 question. So my advice to you is to ensure that you look at the marks. This is beautiful that CAPE does this at university. At university, they give you a question, they say it's 50 marks. You don't know what part of the question has what, and you just have to just roll with the flow. In CAPE, they tell you how much marks is allocated to everything so that you know how much you should write and you're able to keep track of time. I also have that the A student will take into consideration her origin, history, where the law is coming from and where it is now, especially given that it is an essay question. You are expected to acknowledge history and where the law, because that is really what your examiners are trying to test, how much you know about the law, how much you know about the development of the law, especially for module 1. And the last thing I have here is that the A student will always try to explain briefly why law overall or why that specific area of law was necessary. We call it policy considerations. It's where you look into why the legislature or why the policymakers may have passed this law. What are they trying to benefit? What are they trying to achieve rather? Who are they trying to benefit? The A student or the A++ student always look at that. That develops the perfect essay. When you conclude and then you say the law or the policymakers may have implemented this because they wanted to protect the fundamental rights of persons, just for example. So the the A student always have a policy consideration, and a policy consideration is basically looking at what the law was trying to achieve or why they felt like implementing this law was necessary. So for the past paper question for module 1, so I have a couple questions for module 1 actually. We'll go through these questions, and then after that, we'll take a break and we'll come back to module 2. So for the first module 1 past paper question that I have is, describe the court structure in a named Commonwealth Caribbean country, showing how it facilitates the doctrine of judicial precedent. B, discuss two advantages and two disadvantages of the use of judicial precedent by judges in deciding cases that come before them in the courts in a named Commonwealth Caribbean country. Now, this question was not worth more than, B was not worth more than 10 marks. I didn't put it there, but it was not worth more than 10 marks because it's 25 in total. So that means the A student should recognize that the majority of my work should go into part A, right? And then I explain part B, but you can't do it the opposite, like giving part B because you know part B, you're giving part B more and you leave out part A because you're going to lose marks, and you're trying to get as much marks as possible, especially if you're not strong on the other two modules. All right, so what would the A student do with this question? The A student would first recognize that this is an essay question. Why? Because it says describe the court structure, and then B says discuss two advantages. So if you want to go on and write whether this and whether that, and you want to turn it into a problem question, God go with you, but it is describe and discuss, and this is how you All right, sorry about that. Are you guys hearing me?
Yes, Miss.
Okay, yes, thank you. Give me a second. My internet went down. Are you able to see my screen as well?
Yes, Miss.
Oh, okay, all right. So I was saying that the A student would explain what is judicial precedent, ensure to identify that it is a source of law, and you would also explain what are sources of law and why are sources of law relevant, and you would do that briefly. You'd probably identify the other sources of law to say other sources of law includes the Constitution or legislation and equity, and you just do it briefly. You don't need to go into what is the Constitution. That is not what the question is asking. You just need to give a brief overview of what sources of law contains, but your main focus should be on precedent, because again, that is the key term of the question. Now, the A student must explain that judicial precedent is central to common law, right? And you must identify and explain that it is essential to the ad hoc nature of common law, which is basically developing legal principles on a case-by-case basis, because this is what precedent is about. So you will now need to note also that there are two types of precedent. You have binding precedent and persuasive precedent. So basically, this is where you're given an overview of what is judicial precedent, how it came about, and why is it relevant. Court structure. Sorry about that. Give me a second. Able to hear me?
Yes, miss.
Yes, miss.
Yes, miss.
Okay. All right. So the student I was speaking about bringing precedent into the Commonwealth Caribbean court structure. And basically, I was saying that we focus on stare decisis. And if you can remember, this would probably be good for you in terms of marks, if you, or in terms of impressing your examiners, if you can remember the full maxim, which is stare decisis et non queta movere. If you can remember that, then sure, you know, they would probably be impressed, but I don't really think you're going to lose marks if you don't remember that. I think all you really need to do is remember stare decisis, which basically means standing by decisions and not disturbing settled points. Or easier form is basically letting the decision stand, let the decision stand. So I think if you can just remember that we focus on binding precedent in the Caribbean, which is known as stare decisis. There's stare decisis, and stare decisis means let the decision stand. I think you should be fine from there. I don't think they are going to kill you for that. And it's better than trying to remember the long terms and the long meanings and you can't remember them. Simply is better. I don't think simply ever killed anybody. I was pretty simple in my exams for CAPE and I did get one. So I think you just need to ensure that you remember what is basic, which is that we focus on binding precedent. It's known as stare decisis, and it means letting the decision stand from a previous case, right? This precedent is seen as more important because it allows for the preservation of case law principles. A student, in my view, will then note that in order to better understand the doctrine of precedent, they will examine the court structure of a Commonwealth Caribbean country. I think transition words or transition sentences actually make your SSC, better. So after you have explained what is precedent, you explain that in the context of the Commonwealth, and you go from broad to narrow. So you say, what is precedent? You explain it's a source of law. You explain that in the Commonwealth Caribbean court structure, we mainly focus on binding precedent. Then you go into actually naming the Commonwealth Caribbean country that you will focus on. And this is completely up to you. But again, take my foolish advice. If you come from Jamaica, I advise using Jamaica. If you come from Barbados, use Barbados. If you come from Trinidad, use Trinidad. I don't think you can go wrong with that because you know your country better than anybody else. If you have visited other countries, if you have studied other countries, especially because you guys are first years in Cape, unless you have visited other countries or you have some strong background knowledge of those countries, I advise that you use the country that you live in. Now, the A student, after naming the country, this A student must recognize that in this country, the Constitution is still the supreme source of law, followed by statutes and then judicial precedent. Because you have to remember that judicial precedent speaks to case by case. You must still understand and you must show your examiner that you know that the Constitution and statutes are, well, Constitution then statutes is what the judiciary or the court will look at first. If they don't have anything in the Constitution that is applicable to the scenario or the case that is before them, if they don't have anything in terms of a legislation, statute, whatever you want to call it, statute, legislation, if they don't have anything in terms of that to direct the case that is before them, they will look at other cases that have come from other courts. And this is where you get into the meat of the matter to say judicial precedent or binding precedent. It refers to where the court, that is especially the lower court, look at cases from and decisions that have been made and have been settled by higher courts. If you're speaking to Jamaica as being your named Commonwealth Caribbean country, you are going to look at the fact that the Privy Council is our final appellate court, and the Court of Appeal is our second highest court, and then you have the High Court. What judicial precedent means, and the student must be able to explain this, that judicial precedent means the lower court or the High Court is expected to follow any decision that is made, settled, and concrete in the Privy Council or in the Court of Appeal. The Court of Appeal is expected to follow what is settled in the Privy Council. However, it cannot go vice versa. So the Court of Appeal is not expected to be bound by a decision by the High Court, and the Privy Council is not expected to be bound by a decision by the Court of Appeal, because if judicial precedent went back way, then it would defeat the purpose of having an appellate court. So if the appellate court is relying on what they can do, they can decide to keep the decision. You know, you'll see cases where the Privy Council will agree with the Court of Appeal and they will say, we'll send back the case to the Court of Appeal for sentencing or for judgment or for anything, but they're not obliged to. Right? They're not obliged to. There's no stare decisis in terms of the Privy Council listening to what the High Court have to say, or the Privy Council listening to what the Court of Appeal have to say. There's no stare decisis there. Anything there becomes persuasive, but I'm trying to not cloud your brain. So I'll go in order and then we'll go to persuasive. But basically what precedent is that the decisions from the highest court, binding precedent, the decision from the highest court is binding on the lower courts. They are expected and obliged to follow them. And of course, the A student have to use cases. And so I have a case here. I do expect you guys to, use this, or you can use something else, whatever you're used to. But I think this case basically covers the general rule, and it's London Tram Cars Co Limited and London County Council. And here Lord Alice Berry would have said that a decision of the House once given upon a point of law is conclusive upon the House afterwards, and it is impossible to raise that question again as if it was res integra and could be re-argued. And so basically what he's saying here is that whatever decision has been made before, you have to let the decision stand. But in his context, and you might need to explain that, in his context, he was talking about if the decision was made by the House of Lords, before it is binding on the House of Lords again, but you now have to explain that it is also binding in your jurisdiction upon the Court of Appeal and upon the High Court. Cases showing binding precedent in Jamaica. I just had here, like, think for example, Pratt, and how has the decision of the Privy Council affected subsequent cases. Think, for example, Hines, and how has the decision of the Privy Council affected subsequent cases. So you know that because the decision of the Privy Council was binding and it would have established how you go about cases where you would think about, you know, giving sentencing persons to the death penalty, there are certain procedures that you have to follow, and it is binding on the lower court. So whenever a case comes before them and it has anything to do with the death penalty in terms of Pratt, you would realize that they would refer to Pratt, and there are other cases that they would also refer to, like Trimmingham. I think you guys would have learned that as well. They would refer to those cases and they would say, okay, this is what we're going to do, or how we're going to do it, or how we are going to rule on this case, because the decision of the Privy Council in Pratt was one of binding precedent, meaning that other cases which come after that must follow the decisions or how this case was basically ruled or concluded. There are exceptions. There are exceptions to the doctrine of precedent, and the A student will be expected to explain that there exists persuasive precedent. And what persuasive precedent means is that the decisions arising from courts outside of your court structure, and I say outside of your structure and not just outside of your jurisdiction. Some books, some things would say outside of your jurisdiction, but you have to be careful with that because the Privy Council is outside of our jurisdiction. However, it is within our court structure. And I believe that's why CAPE structured, or that's why CAPE CXC wrote the question like that, to say your court structure, because a court might be outside of your jurisdiction, but it is your final appellate court. So that's why I said structure or jurisdiction. Basically, again, what persuasive precedent means is that if the court is outside of your jurisdiction or your court structure, it can't be binding, it can't be stare decisis. What it is obiter dicta, which means things that are said by the way. It means, oh, the court said this, and oh, the court in America said this. We can use this to guide us. This is persuasive, but we are not expected to follow it. So you can say, oh, the court in America says that you can sentence somebody to 50 years if they kill their mother. Okay, that sounds practical, and we might want to say, okay, you kill somebody, this is like really strange, really weird, it's really disgusting, and we want to give you 50 years in accordance with this case. But it is not like it is something that is saying you have to give the person 50 years, because they're not in our jurisdiction and we're not bound to follow them. It is the same with the CCJ. If you want to come closer to home, the Caribbean Court of Justice can make decisions and Jamaica can follow them, but Jamaica is not bound to follow them, because Jamaica is, the CCJ is not our final appellate court. It is not the Privy Council. So we are not bound to follow them. And I had a case here, I think it's, yes. So I had a case here, Boudram and AG. And in Boudram and AG, what happened was that the Court of Appeal of Trinidad had relied on a decision from a Jamaican court. They weren't obliged to, but they were saying, because we have a common legal system, they're going to use this as a guide. But they weren't obliged to. If they decided to steer away from that decision, nobody could hold them accountable. Nobody could, say the court was unfair or the court was biased, because they're not bound to follow anything that is not within their jurisdiction or their court structure. And the A student must acknowledge this exception. So the A student cannot just talk about binding precedent. The A student have to explain that, however, if the court is not in our court structure, they pass a decision, we can use it as a guide, but it is not binding on us. I had here that the Court of Appeal is bound by its own decisions unless it can be proven that such decisions were given in error. Basically, this was really connecting back to the fact that, hold on, give me a second. Sorry about that. So basically, it was connecting back to what I was saying when I explained that the Court of Appeal is not bound by the decisions of the High Court, and it's also not bound by any decisions made within the Court of Appeal before, unless it was given in error. So unless they feel like this judgment or this decision did not make sense, that's the only way that the Court of Appeal is expected to make any change, or is expected to follow any case that was said before or from the lower court. Additionally, I have that the A student will explain that there are other terms of judicial precedent. So you must expect that if you see a question talking about precedent, even if the question only requires you to talk about stare decisis and another term, or 2 terms or 3 terms, you must still give your examiner that knowledge because it is an essay. Right? You must still give your examiner that knowledge to say, hey, I still understand that there are other forms of judicial precedent which are applicable. Of course, you don't need to go too far into them because they're not literally connecting to your question. So you just refer to them briefly. And the other terms, ratio decidendi, which is the reasoning upon which the case turns, or as it would say here, principles at law at which the court arrives at the decision. And it differs from stare decisis. So stare decisis says let the decision stand. However, with ratio decidendi, if the case is not exactly the same, the lower court can make an examination to see if the principles are applicable. Once they see that the principles are applicable, they must, in their judgment, explain which specific principles are applicable. Different from stare decisis. Stare decisis means let the decision stand. So stare decisis usually looks at the same case. It's usually the same facts, the same thing, and you're saying let the decision from the Privy Council stand. But ratio decidendi means you're identifying specific principles for the case that is before you. Distinguishing the case is another term that is used in judicial precedent, and it means that the lower court is able to distinguish the case if the facts or circumstances of the case that is before them is different from the one that the precedent decision is coming from. Overruling the case, the doctrine allows courts to overrule a case, means they can set aside the decision of an earlier case if they don't think it is applicable now, or if they don't think the judgment was made fairly. However, the lower court cannot overrule a case. They cannot overrule a case from the superior. So if the Privy Council say this is gold, the lower court cannot say it is black, because it is coming from the Privy Council. But on the other hand, the Privy Council can overrule a case from the lower court. Conclude, I have here, you must conclude your essay by indicating that judicial precedent is very evident in the Court of Jamaica, if that is your name, Commonwealth Caribbean country, and you must just give brief illustrations from what you would have written. Your conclusion, as I have here, is like more than 2 marks. So I really don't want you to go in there writing a whole other essay for your conclusion. Just indicate that it's evident here in our court structure, and this is what it is, and you just wrap up. You don't need to go into a whole nother book. Part B of the question says advantages and disadvantages of judicial precedent within your court structure. And basically, this is, again, bringing us back to where I said the perfect student would have a policy, like what the law is trying to achieve, why the law has, why was this law created, why would we have judicial precedent, why is it necessary? And basically, I have 2 advantages here to say legal certainty means that the individual that is being tried can know what is wrong and what are the consequences. So as you go further in law, if you want to continue law, when you get to university, you'll hear a lot about legal certainty. To say if a law is passed and it is not legal certain, there is a problem, because the person who is being tried under this law or liable if it's civil law they don't know that it is wrong, so you can't expect them to do better. People must know what they're getting themselves into and should know what and what not to do. That is why judicial precedent becomes important, especially if there's no statute or nothing in the Constitution to speak against this. At least the person can look and say, well, in the case of Eisenhower, we know that the parliament can't do this or the parliament can't do that. And so judicial precedent becomes important in legal certainty. It also becomes important in legal precision, which means the court is less likely to deviate from those that are tightly connected to this case. So I, as a citizen, and judges, it helps citizens. So judges and citizens can know that, hey, well, at least these two cases are related and I know what to do here, so that you don't have them thinking in a whirlwind as to what would be applicable here and making any big mistakes. Disadvantages, however, the lower court is bound by what it might consider unfair. Like the Court of Appeal might make a decision that, or the Privy Council might make a decision that it doesn't seem fair, it doesn't seem right to the citizen, but the lower court is expected to follow it because it is a binding precedent. And another disadvantage is that sometimes there is this high volume of cases, you have decisions changing between the Court of Appeal and the Privy Council, and the case comes before the lower court, and the lower court is expected now to just, go through all these cases just to find what principle is applicable. That may also cause some confusion, and that is not really practical. So it may be a disadvantage of legal precedent. The next question I will go into for Module 1, it says casting a Commonwealth Caribbean state is considering severing all ties with the Judicial Committee of the Privy Council, advise the Attorney General considering 3 benefits to be gained and 3 disadvantages of submitting to the Caribbean Court of Justice. I think this is one of the best questions you guys could ever get because it is literally straightforward. I gave some points here. Features of the CCJ. CCJ is the final appellate court of Guyana, because if you're writing an essay question, you can't just go into saying, oh, the 3 features of the advantages of the CCJ is this. So you need to give your examiner some beef. Assume that your examiner knows nothing, and you need to explain that the CCJ is the final appellate court of Guyana, Trinidad, and recently St. Lucia. The CCJ has an appellate jurisdiction which hears appeals from the lower courts, and it has an original jurisdiction which hears issues between states or matters arising under treaties or trade disputes. And you might want to explain on the Privy Council a little bit, because we are doing some form of comparing and contrasting based on the question. It's saying, what are the advantages? Why should we change from the Privy Council to CCJ? So you want to give some background on the Privy Council as well. And I have the JCPC, which means the Judicial Committee of the Privy Council. I want you guys to get that, because it comes on the module 1 as well, I think, where you will learn about, or is it module 2? I think it's more module 2, where you will learn about the Privy Council, which advises, well, it wouldn't be the Queen anymore, it would be the King. So you want to be careful not to mix up those two. The final appellate court for Jamaica is not just the Privy Council, it's the Judicial Committee of the Privy Council, which hears issues coming from the Court of Appeal. So you want to make that clear. It is located in the United Kingdom, and as I have here, it's the final appellate court for several Commonwealth Caribbean countries, including Jamaica. Advantages and disadvantages of the CCJ. advantages I have here at the court is locate CARICOM relation and social studies kids understand what is the Treaty of Tragaramas. And it also deals with matters relating to the Caribbean single market economy. And so when we all countries participate in CARICOM and matters of CARICOM relations, go to one court to deal with it, it is much better for us. It also reduced the need to go to international courts, because if all of us don't use CCJ, then we can't go to CCJ with all the problems relating to CARICOM. We're going to have to get the help of the international courts. But if all of us go to CCJ, then if all of us have CCJ as our final court, then it's easier for us to just go to one place and deal with all our issues. And that's one of the advantages of the CCJ. Another advantage is that the court uses Caribbean judges, and it is believed that the Caribbean judges understand the Caribbean people. And so when a case comes before them, they have more of compassion or emotional connections, and they can understand what is going on. And so in their judgments, it will be fair. It will be, with an understanding that these are my people and this might have been what they were going through or what they were thinking, as opposed to some people who are the country who have no connection to us people. And so that is one of the advantages of the CCJ, is that the judges are like us. They're like you and I. They are of our skin color. They are from or villages or districts or communities. They understand what we are going through. Another advantage is that the CCJ allows for upward mobility of Caribbean people within the legal profession, because it would be the Caribbean judges, it would be Caribbean lawyers, it would be Caribbean people working as clerks and any other position within the court. And so it allows for our own people to grow, as opposed to people, again, that you just don't know, who are just selected wherever and however, and they're dealing with the situation. So it makes you feel more comfortable. It makes the people, the general citizens, feel more comfortable knowing that their own people can benefit from a court that is established within their region. Disadvantages. I have here a lack of experience in comparison to the Privy Council, which has been around for years and is working fine. This is a personal opinion, and it may be others' personal opinion, and people may not believe that, but you would have had many cases which have come from the Privy Council, and they have worked fine. We like them. We like the decisions, especially when it comes on to human rights cases. And so one of the disadvantages of having the CCJ is that you have moved away from some of those decisions, and also the CCJ is not so experienced. It's not so, in terms of age, it's not so mature like the Privy Council. And so the thought that comes to the minds of many persons is that the CCJ is going to rely on the decisions of the CCJ. Sorry, the CCJ, is going to rely on the decisions of the Privy Council. So why change the Privy Council? So sorry for that. So one of the disadvantages of changing is you're getting a court that don't have experience and is going to rely on the court that you are moving from. So it really doesn't add up for a lot of people. So a lot of people don't think it's necessary to move from the Privy Council if the CCJ is going to have to rely on the Privy Council decisions. Further, there are not enough judges to deal with the matter. I don't know if you have ever read a good amount of cases from the Privy Council, and you will see so many judges dealing with so many matters, so many different names, some of them that we are unable to call. The belief is that if we don't have that much judges who, although we have competent legal personnel in the Caribbean, that's no question, we don't have so many judges to deal with so many matters, especially when it comes to a final decision. So that is one of the disadvantages. And the last one that I have here is that the judges may be biased and subjected to political manipulation. We are Caribbean people. And I'm sure we're used to it to hear that, links run the world and it's who knows who and who can influence who. I'm not going to say that is going to happen in the court system. And you should not put that on your exam, but you can say may. So there is a possibility because we know in the Caribbean, the nature is links around the world and anything is possible. And maybe a judge can be paid off. And in that way, it wouldn't work for the advantage of the citizens who are really seeking to get help from the final appellate court. However, with the Privy Council, that is not a problem because the politicians more than likely don't know these lords. The lords don't know them. The lords don't care to know them because you're in the Caribbean, they're in England. They don't care about you. You have nothing to do with them. They're just answering the case that is before them. And so that is one of the disadvantages of having the CCJ and an advantage of having the Privy Council where they don't know you. So they're just answering what is before them. Question 3, distinguish between positive law and natural law. And then I have give 2 examples of how natural law affects the system of law which operates in a Commonwealth Caribbean country of your choice. And again, you want to look at the key terms. So positive law, natural law, and how natural law affects or operates in a Commonwealth Caribbean country of your choice. So look at positive law, look at natural law, look at Commonwealth Caribbean country. As I said earlier, in an essay question, it is important to always look at the key terms because if you miss any of these key terms, it will mess you up real bad. So in a discussion, in an essay, you might want to discuss what is law overall. You can probably use the easiest definition that you can find, which is that it is an enforceable body of rules. So that governs a society. So you probably just need to explain that, and then you need to explain that. After that, you need to go into the fact that law is defined in different ways. And the reason why it's defined in different ways is because it stems from different theories and beliefs. The 2 theories that is required for your exam is natural and positive law. So then you go into what is natural law. Natural law is belief that law stems from a superior or divine being and is connected to morality or religion. One of the main theorists for this is Thomas Aquinas, and Thomas Aquinas states that natural law is a higher law that comes from God. I have a textbook that I can send in the group if you are part of the group, and it's Professor Belantoine's book, and it looks at the position of Cicero, and it speaks to how natural law was created to shape human social behavior. I will send that book because I believe it is effective, but don't go writing the whole book on the exam now. You just need to look at the main positions. It's 6 marks for both questions. So you just probably need to see what Cicero is saying and just find a way to tie it into your answer. Positive law, on the other hand, is the belief that law has nothing to do with morals or religion. Rather, it is a body of enforceable rules which have been enforced or approved by the sovereign or parliament. These rules were established to guide human behavior and restore order in society. They must be followed even if they are unjust. And I will again advise you to look in the book and use the position of HLA Hart. Now, how does natural law affects the system in countries? Right, so I looked at 2 cases which I think are really important if you're going to talk about natural law, which is Sean DPP, which speaks to publishing advertisement for prostitutes, and it was considered illegal as it was promoting fornication. And according to court, this is an attempt to corrupt public morals. And we know that the whole idea of fornication comes from the Bible, or comes from religion, basically, because doesn't matter which religion, most religions go against, well, Judaism and Christianity goes against fornication. So you should be able, you'll find this possibly in the Bible or in the Torah scrolls. So that's why I'm being careful as to not just say the Bible, but it comes from religion. And as Christians, if we're Christians, I can only speak for Christianity basically from the top of my head. The Bible in the 10 Commandments said, thou shalt not commit fornication, thou shalt not commit adultery. So Shaw and DPP now, and we know that England operates mainly on a Christian system. So in Shaw and DPP now, if they're going to say that fornication is an attempt to corrupt public morals, the A student would recognize that why this is happening is because of natural law, which is trying to tell us that law comes basically from a superior being, it comes from the divine being. I also have R and Nola, which is basically the same thing. Speaking about, this was promoting homosexuality, and the court was saying it's an attempt to corrupt public morals, and that's basically, again, stemming from religion. There is a case, it is more a tort case, and you'll learn more about it when you go to year 2, but you can use it just for explanation. Donahue and Stevenson, where someone had bought a drink and the drink contained a slug or a snail, and the company was held to be liable as one should not bear false witness against thy neighbor. And the exact words were used that you should love your neighbor as you love yourself. And we all know that this is coming from, again, the 10 Commandments. How does it apply to Commonwealth Caribbean countries? Again, you need to just select one. You don't need to talk about Jamaica, Trinidad, Barbados, Guyana, everybody. You just need to select one. And in Jamaica, we have the Offenses Against the Persons Act, and it makes it a criminal offense to commit murder. And this I have here that it connects to the 10 Commandments. So you do remember that the question say you must talk about two ways which it applies to a Commonwealth Caribbean country. So I have here the Offenses Against the Person Act, which have you shouldn't commit murder, and that connects to thou shalt not kill, which is one of the 10 Commandments, and you shouldn't commit robbery or burglary or anything of the sort, and again that connects to one of the 10 Commandments, which is that you should not steal. So that is one way. All of that is one way how it connects to Jamaica. Another way is that Commonwealth Caribbean countries, and I think a lot of people like this, when you see lawyers and you see them in their black and you see them with that white thing that's coming from like their neck, those white things, those two things, it's actually called the advocate's ban. And what the advocate's ban represent is the tablets of the law. And the tablets of the law are basically the 10 Commandments that Moses received on Mount Sinai. So the fact that we have even our lawyers and judges or legal personnel wearing this type of outfit, which represents religion in its rawest sense, basically that is one way how natural law applies to our country. Please note that Guyana does not require their legal personnel to keep up this practice, however. I have some advice here, and we're going to take a break for about 10 minutes. And I have some advice here. Well, you can ask some questions and then we'll take the break. Some advice here is you can look at the role of the ombudsman, and you can look at alternative dispute resolution, which is mediation and litigation. And why I have those there is because, again, I tell you, it's 8 topics that I would have seen that you could go through, that you could possibly get an exam. You can get an exam with possibly any of those eight topics. And I see these from the past papers constantly coming back at some point. They're straightforward, so I don't think I needed to, I didn't think I need to go through them, but word to the wise, you can look at them, because there may be a question with precedent or a question with natural law, and then you can't answer that question, but there's a second question with the role of the ombudsman. It's straightforward and you can answer it and you can get your 25 marks. Easy. So take my foolish advice and look at the role of the ombudsman and alternative dispute resolution. Quick. It don't take 15 minutes to go through it. It's really straightforward and really easy. So that is it for module 1. And we'll take a break for 10 minutes and we'll go to module 2. So you guys can ask anything you want before we go on that 10-minute break. All right, brilliant children. Everybody's learning or everybody's familiar and everybody's ready for, module 1 to some extent. So we're going to take a 10-minute break and then we'll come back with a past paper question for module 2. So I will see you back at 4:30. All right, welcome back, everybody. I do hope that you had a good break, and we are going to go into module 2, which is the principles of public law. I had sent a list of things that I think are applicable and things that I think, we don't have to look at so in depth. Now for the principles of public law, it deals a lot with separation of powers, with judicial review, with constitutional supremacy and parliamentary supremacy, with the roles of the service commissions and others. However, last year, the Fundamental Rights and Freedoms came, and the year before, the separation of powers and judicial broad topics that were given by CAPE, and it was easier to focus on these topics. It is my honest belief, and I could be wrong, but you get 2 questions. So one of them could come, but there's, based on what I would have seen when I was doing CAPE, back when we didn't have broad topics because there was no COVID and you were just doing the exam, blindly. If the module has 5-6 topics, it's highly unlikely that 1 year after they're going to repeat directly that topic. So it is my honest belief that, not saying you should not focus on them now because a question might come on them, but you can focus on the other topics that are there a little bit more in depth. And so the topic I will be focusing on for module 2 for this session is parliamentary sovereignty versus the constitutional supremacy. The question is, with reference to at least one decided case, explain whether Parliament or the Constitution is supreme in Commonwealth Caribbean states. Now, the A student is going to try to break down this question. So what is it asking? It is basically asking you which one is in control, which one has more power, whether the Constitution or Parliament. And it says with reference to at least one decided case. So as I had said before, initially, when we started this question, the A student is going to look at every term within the question and see what exactly it is asking. Now, I have here that, again, the A student must be able to define key terms. So what is the Constitution? Because you're asking me which one has more power, the Constitution or Parliament. Now, there's no way I can go in there and just start talking to say, well, based on this case and based on what I would have read here, the Constitution is supreme, and you don't even explain what is the Constitution. So the Constitution is a source of law, and it's the main source of law. I'm giving you a hint here. But again, when you're approaching your questions, you can take a broad approach so that your examiner, just in case your examiner don't understand anything about law, in quotations, you want to give a broad approach to a narrow approach. So I put it as the main source of law because we know off the bat it's the main source of law. But you can take the broad approach to say it's a source of law in a country and continue, because you're going to eventually get to the part in your conclusion where you're going to say it is supreme and it is the main source of law. So you start defining what a constitution is: a source of law in a country, which governs how the country is to be ruled, basically. That's what I should have put there instead of govern, and the roles and functions of each arm of state. So, there are different arms in a country, and even if the question is not specifically asking about arms or separation of power or anything, you need to identify and to explain that. So there are different arms in a country. You have the executive, the judiciary, and the legislative. And you must explain that the Constitution states how these arms are supposed to be run. It states how the head of state is supposed to operate, the attorney general is supposed to operate, all those persons. It states how everyone with an important role in a country, their roles and functions are set out by the country's constitution. It is also a source of law which protects, or the main source of law that protects the fundamental rights and freedoms of all citizens within a specific country. And I think we're all familiar with the Charter of Fundamental Rights and Freedoms. And again, even though the question is not about fundamental rights and freedoms, you want to show your examiner, because the truth is, when an examiner gives a question, even though it's specific to a certain topic, the examiner wants to know that the student was reading. So they want to know that even though we're giving you 2 topics out of the 6, you are versed on the 6, because you should have been studying for the 6, because you should not have a cheat code. So you should be going through the 6 topics. And so you want to emphasize that the Constitution protects fundamental rights and freedoms. You don't need to go into what All right, sorry about that. Are you hearing me, or are you able to hear me rather?
Yes, miss.
All right, so what is Parliament? Parliament is established, or was established, by the Constitution, and I put hint because it is a hint for how you stir your debate. I can tell you how to stir your debate. You can say Parliament is sovereign, because I mean that is up to you, but again, I just want to emphasize that this is not literature. It's not one size fits all. The law is there, and you want to ensure that your question stirs in law. It's not like, oh, it's anything you think, as long as you can defend it. The law is the law, and the law can change. It doesn't matter how the question is written. It doesn't matter how you answer the question. The fact is, the law is a law, and the law can change. So you have to use the law. And so at the end of this, I'm going to just say right off the bat, the Constitution will be supreme. But again, it's directly up to you. But a student who wants the one will understand that the law is a law, and the law can't change. So I would hear Parliament is established by the Constitution. That is a hint to show you that even Parliament itself comes out of the Constitution. Section 34 of the Constitution, to be specific, is what allowed for the creation of Parliament. Parliament in Jamaica, and you want to steer to a specific Commonwealth Caribbean country, and you want to, be specific with that so that you don't get confused, because different countries may have different systems. So Parliament in Jamaica is bicameral, meaning it has 2 chambers. It has the lower house, which consists of the House of Representatives, or to break that down further, your members of Parliament. So it has 63. The House of Representatives, or the lower house, has 63 representatives, because we have 63 members of Parliament. So if you can't remember that, just remember 63 MPs. So if you can remember the 63 MPs, if you can remember that you have 63 MPs, then you'll remember that the House of Representatives has 63 members. Then you have the upper house, which consists of the Senate, and these persons are non-elected. And that's a given. The 63 MPs in the lower house are elected. They're the people you go to the polling station and you vote for. But the upper house, it's non-elected senators. They're selected by the Prime Minister and the opposition leader. 13 senators are selected by the Prime Minister, and 8 are selected by the opposition leader. So that's a total of 21 senators in the upper house. So again, Parliament has 2 chambers in Jamaica, lower house and upper house, 63 members of the lower house, 21 members of the upper house. Now, the Constitution is the source of law which indicates how the members of the lower house can be elected. It also indicates who is eligible to be selected for the upper house and how the speaker, clerk, deputies, clerk, and marshal of the house are to be appointed, how the president of the Senate is to be appointed. The Constitution also gives the roles and functions of these persons. The role of Parliament, according to the Constitution, is to make laws for the peace, order, good government of Jamaica. That is section 48. Now, the A student must recognize that this is where the problem starts. So in your essay, you need to indicate that why we even have a question as to what is supreme, whether Parliament or the Constitution is supreme, is because we have a provision in our Constitution which states that Parliament was established to make laws for the peace, order, and good government of Jamaica. Basically, what is happening here is that the Constitution gave Parliament the power to make laws. Where a problem comes to the Constitution. So again, the A student recognize that this is where the problem starts, and it gives Parliament the power to make laws, and it literally just said laws. So any law at all. So what happens when the law is ultra virus to the Constitution? So this is where you get into the debate. So which is supreme? The A student must know that section 2 of the Constitution of Jamaica of your specific. All right, hope you guys are seeing and hearing. Okay, so section 2 notes that the Constitution of Jamaica is the supreme law and is subject to sections 49 and 50. It also states that if any other law is inconsistent with the Constitution shall prevail. So off the bat, we're seeing that basically the Constitution is saying it's a supreme law. So any statute, policy, anything that is made that is not in accordance with the Constitution shall not prevail. So why do we even have a problem? But the Constitution, after section 2, goes ahead in section 48, says that Parliament can pass laws. The Constitution also allows Parliament to alter it. So the Constitution can be altered by Parliament. However, the supremacy of the Constitution is shown in the fact that these provisions are entrenched, which means they cannot easily be changed. So it's not saying it can't be changed, it's just saying that you can't just go into Parliament and pass a bill and simply just vote on it and change certain entrenched provisions in the Constitution. You have to go through a process. So I have here that section 50 allows for Parliament to alter the Charter of Fundamental Rights and Freedoms, but not by a simple majority. It has to be a 2/3 majority. Similarly, we are going through a constitutional reform process now where we want to become, or Jamaica wants to become, a republic by 2025. Now, the provision in the Constitution, it allows for the Constitution to be altered to allow us to move from the monarchy to Jamaica being a republic. There's also a part in the constitution which allows Jamaica to change from the Privy Council to the CCJ if they want to, but they must follow a certain process. So Parliament, yes, has the power to make these changes, but it has to be within the context of the Constitution. So, for example, with the changing from a constitutional monarchy to a republic or to a parliamentary republic, Jamaica has to, when the bill is proposed by the Minister of Legal Affairs, Mrs. Malahou Fort, when she and her team comes up and have their meetings and decide that, okay, this is going to be the bill, and she presents it to Parliament now has to have like 6 months worth of debate. They have to have 6 months between when the bill is first, mentioned in Parliament. So they have to have 6 months of debate, and they must have a 2/3 majority and not a simple majority. And there must be a referendum where they come and ask you and I what are our thoughts, whether we want a republic or not. If they mess up one of those processes, any one of that, if they don't do the 6 month thing, or they do the 6 months, but they had a simple majority vote, or they had the 6 months and the 2/3 majority vote, but they don't have a referendum, somebody can bring them to court. And so they can pass the law because it's ultra virus to the Constitution, meaning, yes, Parliament has powers, but the Constitution says you must do it this way. This is how you should pass the law. And if you don't pass the law this way, if you don't pass the law this way, regardless of the powers that you have, the Constitution will remain supreme, and you can't pass the law because it's ultra virus to the Constitution. So as I have here, so although Section 48 has given Parliament power to make laws as they see fit, these laws must still be in accordance with the Constitution. If not, they would have been ultra virus. Now, the A student, again, reads the question carefully and must recognize that the question is not simply asking you to compare and contrast. Rather, the question asks you to refer to a decided case. And 2 cases are applicable, but I will start with Collymore and AG because I believe that's the initial, that's where we initially got the gist of constitutional supremacy. So this is a Trinidad and Tobago case. And what happened in this case is that Parliament passed a legislation, the Industrial Stabilization Act. Members of a trade union applied to the High Court for a declaration that the statute was ultra-virus to the Constitution, as parts of it contradicted and ignored the fundamental rights and freedoms offered to citizens in the Constitution. Wouldn't CJ, who, this was a court of appeal, wouldn't CJ held that Parliament may be sovereign, but only within the limits of the Constitution, as it is still subjected to the provisions of the Constitution. Thus, if it should make any law that the Constitution forbids, it will be ultra-virus. He continues to note that the Supreme Court has a duty to guard the Constitution, and thus it has a right to make binding declarations if an enactment passed by Parliament is ultra-virus and void. Fraser J. in the same case, give me a second. Sorry about that. Fraser J. in the same case held that no question of parliamentary sovereignty arises. Parliament can only amend the Constitution if Parliament observes the prescriptions of the Constitution. He explains that Parliament is only sovereign if it fulfills the requirements of the Constitution. This shows that the Constitution is sovereign, because even though you can make laws and you have the power to make laws, you can only make these laws per the Constitution. And then I have here that the A+ student would use Collymore, but I think a student can use Collymore and it says one decided case, and sure, I think they will give you your marks for the one decided case, but we all should know Hines. And we all should understand the weight of Hines and the importance of Hines, and that and this is not just for CAPE, this is for Unit 1 CAPE, Unit 2 CAPE. When you get to university and you start to do constitutional law, administrative law, any kind of law and legal systems, you will understand that the A+ student never leaves out Hines. So Collymore by itself is good for any question to do with separation of powers, judicial review, parliamentary sovereignty versus parliamentary sovereignty, versus constitutional supremacy. But the A++ student understands that you don't leave out Hines. Hines is a locus classicus case for anything to do with a topic such as talking about whether something is ultra virus to the Constitution. Locus classicus means it is the standard. It is what is upheld. It is what is respected. Hold on, give me a second. Yes, so that means it is a standard. It is what is upheld. It is what judges look to. This is what judges will use to make an example. And so the A+ student should not leave out Hines in any given moment. So I have here that in this case, the Jamaican Parliament passed the Gun Court Act of 1974, which established a gun court to rule over cases involving gun crimes. 1 second. So I'm sorry if my background is a bit noisy. So in this case, the Jamaican Parliament passed the Gun Court Act in 1974, which established a gun court to rule over cases involving gun crimes. The court was to have 3 divisions: an resident magistrate division with a resident magistrate, a circuit court division with a Supreme Court judge, and a full court division with 3 resident magistrates. The act also allowed for a mandatory sentence of detention at hard labor the General's pleasure for certain offenses. This was determinable only by the Governor General on the advice of the Review Board, a board which only had 1 member of the judiciary. The appellants were convicted in the resident magistrate division and were given mandatory sentences of detention, at the Governor General's pleasure. They appeared to the Court of Appeal and then to the Judicial Committee of the Privy Council, contending that the act conflicted with the Constitution and should be declared void. The Judicial Committee of the Privy Council did not see majority of the issues complain of being contrary to the Constitution. However, it found that the Review Board, comprising of only 1 member of the judiciary and not many persons who were qualified to exercise judicial powers, was contrary to the Constitution, as the Constitution did not give Parliament any power to transfer any functions of the judiciary to a review board. Now, in your assessment of Collymore and Hines and any additional information that was provided, it is up to you to draw your conclusion and your policy, because I did tell you to remember to always have a policy. Now, but as I had said earlier, is that law cannot be, the law is a law. And it doesn't matter what you write, you can't change the law. And it is my honest opinion, I'm just giving you my opinion, is that the Constitution is supreme. Right? Parliament does not have power to go against the Constitution. And why I would say that is because it's like you're 15 and you think you rule yourself. But everything you want to do, you have to ask your mother to do it. And if your mother said don't do it and you do it, you know you're going to get into problems. That is how the Constitution and Parliament works. The Constitution is the mother and Parliament is the child. They can decide they want to do things because, you know, you get some leeway, you get some opportunity to go out and do what you want to do. So you can make these laws. But if you make a law and the law is ultra virus and the law is against the Constitution, or the law does not follow the prescriptions of the Constitution or the methods or the steps that the Constitution said that they should take to make them, then the law there will be a declaration of the court that this is ultra virus to the Constitution and it cannot work, it cannot be passed. So yes, you have power, but everything you do, even the very establishment of this institution, Parliament itself, can only be established in accordance with the Constitution. So everything they do is in accordance with the Constitution. So therefore, it is my honest belief that the Constitution is supreme. Again, you can come to your conclusion because it is your debate, but you cannot change the law. And based on the cases that you would have seen, Hines and the decisions that came from those cases, especially Hines, which is the locus classicus, you would have seen that the Constitution is supreme. I did tell you not to just conclude without a policy. And remember when I said in the first module that, give me 1 second. All right, sorry about that. So I did say earlier that you should not end without a policy, and I explained to you that what the policy means is what were the policymakers trying to achieve? When our Constitution was drafted, when it was approved, when it was enforced, what were they trying to achieve? You know, why even allow Parliament to make laws and then, you know, they can do it the way they want to? It's because we must understand that law is not just there to say, oh, you can't do this or you can't do that. It's also there to protect citizens. The drafters of the Constitution would have understood basically that we need to have a system in place where we have people, because the law is constantly changing, the issues are constantly changing, and the law changes with the issues that we're facing. So we must have parliamentarians, we must have politicians, we must have people who say, oh, this is the issue, and we need to build a law, or we need to make a law that will govern this, and so that the people can be satisfied. But at the end of the day, the Constitution also recognized, remember when we're talking about CCJ and the Privy Council, that you have some biased people. You have some politicians and some persons who are probably not in here with the best interests of people at heart. And it did the Constitution recognize with the Charter of Fundamental Rights that we have rights and freedoms that must be protected. And so you cannot give Parliament ultimate power to where make laws that will tramp on persons. You need parliamentarians. You need them to make laws so that the laws can change with the times. But at the end of the day, you must also ensure that the rights of citizens are protected. And I would hope if you get an essay like this or any essay at all, that this is how you develop your essay with a policy, that you bring your mind to what the law was trying to achieve. Because that is what your examiners are trying to get. That not only does the student read and remember and put back on a paper, but they understand the law to the point where they can say, this is why it was created. That is the A++ student. That is the one straight A student. So please always remember that. We are going to go into crib, but because I didn't want this to be a very long session, and we were kind of on course for 3 hours. I want you guys to ask any question you want to about this, and then we can go into CRIM, which CRIM will be a more interactive session because we're going to do a question together. So for CRIM, I'm mainly going to show you how to do the IRAP method. I really want you guys to be able to answer your questions. I want you guys to go into especially the offenses of the person, which I think is going to come anyway. they're going to ask you about somebody stealing, somebody committing robbery, somebody doing burglary, somebody getting, I don't know, killed or ran over. But I do want you guys to, you might not get a question on sentencing because that came, and just criminal liability. But anyway, you take it, you're going to have to answer on criminal liability, because even when they go into specific offenses, you have to speak to how criminal liability applies to these offenses. So we're going to go into that. It's going to be more interactive because I've been talking for the past 2 hours and nobody has been responding and nobody has been asking questions, and I did not just want it to be a lecture. I really want it to be a tutorial. So anybody has any questions on 2 before we get to module 3? I'm waiting. All right, so somebody asked about the function of the head of state. So you know, the head of state for us is actually a king. This, I would not have prepared to deliver on the function of the head of state, but I can get that information. I can get that document to you. I do think it's straightforward in a way, but I can get that document to you. So you know, our head of state is the king, and he is represented in our country by the governor general. The roles of the governor general, and I'm just talking off the top of my head, are mainly ceremonial. We know that persons cannot be appointed to certain roles without the assent of the governor general. So for example, none of the parliamentarians can take office without being sworn in, and they're sworn in with by the governor general. And the speaker of the house, as I said before, the clerk, deputy clerk, the marshal, attorney general, ombudsman, director of public prosecutions, and the list goes on. All these persons cannot be sworn in. Even the chief justice cannot be sworn in without the assent of the head of state, who is represented by the governor general. Additionally, I don't know if I explained to you how a law is passed, but I would assume that you know how a law is passed. You know, it starts as a bill, it is debated in the lower house before going to the upper house, but it must be debated in both houses. Once both houses have approved on the bill, then it is sent to the governor general for his assent. And again, it's basically the head of state. It's so even though you see the head of given, that's when the bill becomes a law. But nothing can happen, nothing major can happen, no appointments and no law can be passed without the assent of the governor general representing the head of state, which is the king. So that's the basic rundown. He also appoints service commissions and other persons who are in charge of other public offices and public bodies. So that's the basic rundown, but I can send a document with more information on the roles of the head of state. And I do advise you to read over that and to read on service commissions, because service commissions tend to come a lot as well. And given that it did not come in the last 2 years, I would give a hint to read on the service commissions as well as the roles of the head of state. Well, I can send you the stuff for the head of state, but read on the service commissions because that's important and it's likely to come. Any other questions on module 2? There are no questions on module. Okay, go ahead.
No, Miss, I was saying no. No questions.
Okay, all right. So we'll take a 10-minute break from module 2. Well, a 10-minute break now, and then we'll come back to module 3, which might be a little bit longer. So you might need to like drink some water and prepare for criminal law. All right, is everyone able to hear me?
Yes, miss.
All right. Welcome back, everyone. Just give me a second. I can share my screen. All right, so the module that we are going to look at now is criminal law. That is module 3. And I think module 3 is where things can get a little difficult. But it's also very interesting in my view. And I think you guys will eventually find that crim is probably it's probably heavier because it has a lot, but it's probably easier to understand, especially in the Jamaican context, on the basis that we live in a country where we see these things in real time, and so you'll find that it may be easier. I'm not going to really go into certain offenses like murder and manslaughter. You can watch back our videos from last year. I think I went into those last year. There's a possibility those that might come, but I wanted to go into sexual offenses. So you'll see that the question I'll focus on will be sexual offenses. And I'm going to want you guys to come along with me and to help me with criminal law. So I don't want to just be talking and nobody's responding. So we're going to do the question together. Yeah, we're going to do the question together. So yes, basically what I'm saying is that I know that in previous years you would have probably seen murder and manslaughter a lot, and well, criminal liability overall, but I still have to go into criminal liability because even when you focus on the offenses, you have to speak to how criminal liability applies. So I'm going to go into criminal liability regardless. I'm not going to go into sentencing too much because I think sentencing came the year before last year. All right, so hold on. Crim is where the problem questions come into play. You remember those problem questions that I was talking about earlier, and I was saying that you need to use IROC. This is where, when I told you about issue, rule, application, conclusion, this is where you're going to see it. Criminal law is where you see the scenarios, and I think it's because it's really easier to put a simple scenario to criminal law. This is where you'll see the simple scenarios coming out a lot, and this is where you are expected to use the problem questions. And I ask that you please avoid turning the problem questions into an essay. You will lose marks for it. Mark went and he decided that he was going to kill his wife, and you're gonna now talk about what is murder. You're gonna explain murder is defined as this and that, and a man can be charged for murder if he has this and that and whatever, and you start to go on, and you have a 3 points and you have a conclusion. No, please do not do that. You are going to lose marks for it. Another thing is they will put advice at the end of the problem question. So you remember earlier on when I was talking for essay and I was saying, oh, you're going to evaluate or assess or discuss. For the problem question, they will literally put at the end of it that you must advise, right? So you must advise the person. And I do want you to, now that I'm on advice, I want you to stick to it. I want to stay on it to explain something. If the problem question says you must advise, after you do your issue, rule, application, and conclusion, please advise. Please put in conclusion, in advising Mark, he can be liable for murder. Full stop. All right, are you guys able to hear me?
Yes, miss.
All right, sorry about that. Give me a second. All right, there we go. All right, so yes, on the issue of advice. So if you don't advise, then you will lose mark for it because that was what the question is asking. And I was saying that you should put a jurisdiction. So once you're starting your question, just put jurisdiction Jamaica so that the examiner can be assured that you will be talking, whatever laws you will be using will be connecting to Jamaica. All right, so example of what not to do. I have something about tort here. It has nothing to do with you. Guys, don't worry about tort. It's not your problem. I'm just showing you what not to do in terms of answering a problem question. So here there was something about a tort is a civil wrong involving a breach of duty. A tort aims to this, trespass of the person is, assault is that, and you have the cases there, and it all seems fine, and it's a nice essay. And then you're gonna be like, firstly, Adam would be liable for battery because secondly, lastly, he would be in conclusion. Please don't do it. Please don't do anything like that for crime. Don't talk about a criminal law is this and whatever between the state and the individual and that and whatever and put in case and you have first and second. No, please don't do that. I am asking you, I am begging you. The minute you go in and you see a scenario and you start to explain and evaluate and discuss, guys, you're going to lose marks. And I'm telling you, I don't know if all of you have introduced to IROC already, but I would hope that you would have been, because the purpose of IROC, how do I explain it? So the purpose of IROC is when you go into court, when you become a lawyer, if you become a lawyer, you don't go to the judge and start to read out and evaluate and discuss, right? You can't just read. You have to go to witnesses. You have to ask questions. You have to have focused questions. You have to get down to the meat of the matter. And the judge might say, oh, you have 50 minutes to present. You can't go in those 50 minutes just reading word for word and just evaluating everything about the law and not really picking out what is the matter. In those 15 minutes, you need to find whether or not the client is guilty. And you have to ask 4 or 5 focus questions as to whether or not the client is guilty. And that's why IROC becomes important, because it develops and it gets you guys to the place of where they want legal minds to go, which is where you begin to ask the meat of the matter. Whether this is this, what is happening here, what is the law that's applicable, apply it and conclude. So that's why IROC is important. And that's why I'm stressing it, because if you guys go to the exam and you write an essay for a problem question and I find out, I'm going to cry, because I have been emphasizing this the whole session, which will be almost 3 hours, that once you see a scenario, once you see advice, please, I beg of you, do IROC, all right? So you are encouraged to use the IROC method, which we spoke about above, and you will see a clearer example of this method when we begin to answer the problem question. The skeleton of IROC, if the question has 4 issues, you should have issue 1, the rule for issue 1 or rules for issue 1. You should have application of the principle to the facts for issue 1, conclusion of issue 1. Then you go into issue 2, rules for issue 2, and application for issue 2, conclusion of issue 2. And then you should have this for all issues, and then you'll have the general conclusion after that, wrapping up everything. So remember I said how you will have if the question has 4 issues, you'll have 4 conclusions plus 1, plus the general one, making it 5. So the issue, you are answering a legal question. And your legal issue must include both law and facts. So, for example, whether Drake, who gently tapped Mark on his shoulder, can be held liable for battery. So you can see where there is a facts. Drake gently tapped Mark on his shoulder. That's the facts. It's there. And then you have, can he be held liable for battery? And that's the, can he be held liable for battery is where the legal part of the question comes into play. So your issue must have both facts and law. Your rule. Your rule is a law relating to the specific area. So you introduce the topic, simple definition, and case. So you say, all right, this is where you might give a little definition. You may say sexual offenses is rape is, or according to section 2 of this act, this is what it is. According to section 2 of the Sexual Offenses Act, rape is da 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 da. And then you give a simple definition, and then you give your cases as well. After you do that, you ask yourself, is there a clear and well-supported principle that applied from a case that I can put into my rule? Is there a test that applied from a case that I can put in there? Is there a leading case in which the judge or court established a new principle or overturned the original principle? Have there been any new developments on the rule, any new cases that pass and change this rule? And are there any cases which oppose the general rule? In your application, I have that it is fun. And I think why it's fun is because the All right, thank you guys, and I'm so sorry about that again. I'm going to ask Theos if you could allow me to share my screen, please. Thank you. All right, so that was basically it for IROC, and then I would have, as I said, I would have explained before that you will have more than one conclusions, and I think everybody has gotten around to that. So I would have noted here that, once we begin the question, to answer the past paper question, you should be able to get a clearer example of what IROC is and how it applies. So the topics that might come on your exam, their advice. So, he wasn't here, let him hear. Applying the basic principles of criminal liability to offenses against the person, applying the basic principles of criminal liability to sexual offenses, applying the basic principles of criminal liability to offenses against property, applying the basic principles of criminal liability to inchoate offenses. None of these 4 topics came in the last 2 years. Guys, I don't think I have to advise you that when is your exams, I think in a week and a half or 2 weeks, that you need to be focusing on these. I'm not saying sentencing won't come. I'm not saying defenses won't come, because when you start to deal with these specific topics, they may have defenses for them. And I'm not saying that, well, I did tell you that criminal liability is going to come anyways. But what I'm saying is that they're going to focus on these. You're gonna see some question talking about murder, see some questions talking about manslaughter, or you might see a question talking about sexual offenses, or you might see a question talking about damaging to property or burglary or anything of the sort. You will see, there's a high percentage you're gonna see those questions because they have not come in 2 to 3 years. Cape had, I don't want to say I am so sorry that my service is not holding up. I do promise that for paper one, it should be much better. Give me 1 second. All right, so I'm going to get into what is criminal law. So I was basically saying to you guys that yes, you have to pay attention to these 4 topics as they might come. So what is criminal law? So in a problem question, you might not necessarily need to define what is criminal law, but I have it here so that you can have a basic understanding of what it is. So this is a system of laws concerned with the punishment of offenders who are individuals who into Carcross and Jones, crime is acted by or concerned with protecting the society and punishing those who threaten the law and order of the society. It also sets up clearly how persons should behave and the consequences of disobeying. So criminal law is usually against another individual. That would be law. Criminal liability, the bulk of topics that are here require you to apply the principles of criminal liability. So we'll look at this. Hi guys, so I have joined with another device. However, you may not, you will not be able to see the slides. I can send the slides after, so just let me know if that is fine.
Yes, miss, that would be fine.
Okay, all right. So basically the rule of, or the principle, sorry, or the definition of criminal liability is that it is a general principle of criminal law that a person cannot be convicted unless the prosecution have proved beyond a reasonable doubt, that he caused a certain state of affairs which is forbidden by criminal law, and that he had a defined state of mind in relation to the causing of the event or the existence of the state of affairs. The event or state of affairs is called the actus reus, and the state of mind is called the mens rea of the crime. This is the definition by Smith and Hogarth. So basically what he's saying is that you can't be charged for a crime unless you have both the act, the state of affairs, and the state of mind. So you must have the state of affairs and the state of mind. State of affairs being the actus reus and state of mind being the mens rea of the crime. So basically, to break it down, and this was on the slide, which was a little bit more user-friendly, you have actus reus plus mens rea plus lack of a valid defense, and that is criminal liability. So one, you must, for example, I can charge you for murder unless you have literally, killed the person with your actions, but also I must be able to prove that you had the intention to commit murder and that you don't have any defense. Because the parts mens rea and lack of a valid defense is what enables you to move quickly from murder to manslaughter. Because if you don't have the mind to do it, and if you have a valid defense, then you are not criminally liable. So again, for you to be criminally liable, you must have the actus reus, you must have the act, you must have the mens rea, the mind and the will to do it, and you must not have a valid defense. Some criminal liability breakdown again, the guilty act plus the guilty mind plus no defense. What is actus reus? Actus reus refers to law, action, or conduct which is a constituent element of a crime, as opposed to the mental state. So actus reus is the action. It includes all the physical elements of the offense to include the consequences of the prescribed conduct and surrounding circumstances. Give me a second. For one to be, for actus reus, you have three things. So you have acts of commissions, which are those acts that you do, that you wanted to do and that you committed, that you did. Like you kill a person, you shoot a person, but you wanted to shoot a person. And you have acts of omission, which means things that you fail to do. So for example, you are in charge of a child and you're supposed to take care of the child and you neglected the child. You can be liable for a crime for the fact that you omitted. You did an act that was an act of omission. You omitted to carry out or you failed to carry out a duty that you were prescribed to do. So that's actus reus. So it's the actual physical element of a crime, and it is where you have either committed a crime or you failed to carry out a duty that you were supposed to do, and the result is that it became a crime. Then you have mens rea. And I'll go to mens rea because I don't want to stay too long. I don't want to stay too long on criminal liability because I want us to get into a question where we can actually apply criminal liability to the question. So mens rea, it refers to the state of mind, either expressly or impliedly. And this is called cross and joint. Now, mens rea is required to establish blameworthiness or fault. So one cannot be, again, criminally liable without mens rea. So without the state of mind, you cannot be held liable for a crime. So if I did not have an intention to kill you, I cannot be liable for a crime. So for example, I use the term driving a lot because I think it's like the easiest thing. You're driving and you lost control of the vehicle and somebody ends up being hit and they die. You did not have the intention to kill the person. Something happened. Yes, the act was you. You end up running over the person, but you did not have the intention to commit the crime. You didn't have the intention to kill the person. You lost control over the car and there's nothing you could have done about it. There is a high percentage that you might be charged for manslaughter and not murder because you did not have the intention to commit murder. So each offense that you will read have its own actus reus and its own mens rea. So the actus reus for sexual offense might be different from the actus reus for murder, or even under offenses of the person. The actus reus for murder is different, and the mens rea murder is different from that of manslaughter. So in your readings, in your studying, I want you to be careful to ensure that you know that there's not just one actus reus for everything, one mens rea for everything. Ensure that you are studying and you focus your studying to understand that each offense has a different actus reus, has a different mens rea, and have different defenses. So the levels of mens rea are intention, which means whether you really wanted to do this, recklessness and negligence, whether you weren't paying attention to something or you ignored something and it resulted in somebody actually losing their life or suffering serious injury. So again, I won't go too in depth into these. And some I'm going to go into defenses, which I think all the bat you should understand that defenses are those things that you can plead to say, hey, I was not fully in control of this situation, or this is what happened, and so hence why the person suffered serious injury or death, but it was not my intention for them to actually die, or I was pushed to the limit to where I had to do this. So there are defenses, and some general defenses are infancy, automatism, which, you know, I love to use my driving example. That is one of them, where somebody goes into a car and they suffer from automatism. They may actually lose control of the vehicle. It's no fault of theirs, and so somebody end up dying. That is a defense. Insanity, you know, insanity means mentally basically mentally ill. And intoxication, but intoxication is one that you probably need to look at differently, because you may not get off from being criminally liable simply because you were drunk, especially if you were drunk, you caused that. So you drank yourself to that point. So unless you can probably prove that somebody did this to you, you may not get off using intoxication. There are also other defenses where you were aware. So the ones that I used a while ago are cases where you might not be aware of what is happening, but there are other defenses where you may be aware, but you were forced to act. And these include self-defense, duress, mistake, and necessity. All right, so I am going to go into the past paper question so that it can become a little bit better for you. Give me a second. And remember, I did say that I wanted this to be more of an interactive session. So I am going to ask you guys some questions, and I do hope that I do get some responses. So the question that I have, yes, thank you, Marisha. So provocation as a defense as well. So the question that I have here, Scott and Marie are members of a study group. Marie goes to Scott's house to study criminal law, but when she arrives, she discovers that other members of the group will be arriving later. She agrees to watch a movie with Scott until the others arrive. While watching the movie, Scott makes sexual advances towards Marie and tries to kiss her. Marie pushes him off and threatens to scream. Scott tells her that he's going to rape her, and she panics, so she did not make a sound. Scott has sexual intercourse with her, and Marie goes to the police station and files a report. Scott is arrested and charged for rape. Advise Scott on the likelihood of his conviction for rape. That's A. And B, would the situation be any different if Marie were Scott's wife? Give reasons for your answer. Again, Scott and Marie are members of a study group. Marie goes to Scott's house to study criminal law, but when she arrives, she discovers that other members of the group will be arriving later. She agrees to watch a movie with Scott until the others arrive. While watching the movie, Scott makes sexual advances towards Marie and tries to kiss her. Marie pushes him off and threatens to scream. Scott tells her that he's going to rape her, and she panicked and did not make a sound. Scott has sexual intercourse with her, and Marie goes to the police station to file a report. Scott is arrested and charged for rape. Advise Scott on the likelihood of his conviction for rape. A. And B, would the situation be any different if Marie were Scott's wife? Give reasons for your answer. Anybody here wants to take the first jab at the first issue? I'm gonna call names if I don't have anybody answering. Let me check the chat. Guys, it's supposed to be an interactive session. I would have hoped, I know you have 2 weeks to your exams, but I would have hoped that, you guys are doing some studies and could at least, provide an issue. All right, so question, anybody knows what is rape and how one can be charged for rape? Sexual intercourse without consent. All right, thank you, Marisha. Yes, so basically it is sexual intercourse without consent, but it's not only, it must, or basically when we say intercourse, we're saying that, yes, thank you, Joseph. That was the answer that I was looking for, is that it must have penetration. Anyone knows what is it? Well, it's basically the actus reus. And so you are going to, I want to put the problem question in a way to say that you are basically answering like how you would answer normally, but you're just using focus questions to do so. So the first issue that I have is whether Scott's act of having sexual intercourse with Marie after the initial dismissal of his advances is enough for him to be held liable for rape. The second issue I have is whether Marie's lack of making sound while Scott was having intercourse with her allows Scott to rely on the defense of consent. And for section B, simple, whether Scott could be held liable for rape, given that Mary, for having rape after having sexual intercourse with Marie, given that she's his wife. So 3 simple issues: whether Scott's act of having sexual intercourse with Marie after the initial dismissal of her advances, is enough for him to be liable for rape. And 2, whether Marie's lack of making sound while Scott was having intercourse with her allows Scott to rely on the defense of consent. And 3, whether Scott could be held liable for having intercourse with Marie, given that she is his wife. And basically, why these questions would have formulated, or why I would have come up with these questions, is based on the scenario 1, and then 2, based on the fact that, it's having sexual intercourse without consent, which is rape. So given that she didn't, all right, so Marisha is saying he is liable. It does not matter if she was quiet or not, the act of penetration without the consent is enough. She did not give genuine consent since she was shocked or afraid, Joseph. So you guys are right. But what I want to do now is to pull your mind, and I see Joseph giving a case. Thank you. And what I want you guys to do is to just pull your mind to the place where you don't just talk and just give me, a few answers, but where you can ask the questions and you can put the principles to the questions, and then you can analyze it, and then you can conclude. That is what I want you guys to do. And that's why I keep asking, because I'm trying to pull your mind. So the first issue, whether Scott's act of having sexual intercourse with Marie after the initial dismissal of his advances by her is enough for him to be held liable for rape. Right? And give me a second. All right, so I'm going to pull up the Sexual Offences Act for Jamaica so that I can give you the guiding legislation. All right, so Section 3 of the Sexual Offences Act of Jamaica provides as follows. So when you ask that question, whether he is liable for sexual intercourse given, let me go back to the issue, whether Scott's act of having sexual intercourse with Marie after the initial dismissal of his advances is enough for him to be held liable for rape. So that is your issue. And for your principle, you're now going to start with, remember when I said the principle is the law. So you're now going to start with saying, after you write the issue, you're going to say, well, Section 3 of the Sexual Offences Act of Jamaica provides that a man commits the offense of rape if he has sexual intercourse with a woman, A, without the woman's consent, and B, knowing that the woman does not consent to sexual intercourse, or recklessly not caring whether the woman consents or not. So you ought to put that. And also, you're going to support this with case law, right? And give me a second. All right, so basically, one, you're going to use Section 3 as your definition to say it happens when you have rape. But then you're also in your principle going to include the fact that it must have penetration as well. And then you're going to look for the definition of penetration. And you can look to Section 2 of the Sexual Offences Act, which speaks to what penetration is. Penetration, it doesn't matter how slight, it is important for the actus reus of rape. So, and penetration, must be with the male genital. So it cannot be, you're claiming rape when the person used another object. Joseph said it could be orally, anally. Yes, so thank you, Joseph, for that. So basically, you're one, as I said, going to list out Section 3, which says that it must be through intercourse and it must be without consent. But then you're going to also highlight the fact that it must be with penetration and it must be with the male genitals. So penetration must be with the male genitals. It cannot be penetration with an object. If it's penetration with an object, then it is grievous sexual assault. So in assessing the question now, you must look at the fact of, one, whether it was rape, in the terms of whether he actually had intercourse with her, and looking at your principles, looking at your facts, you realize, yes, he had intercourse with her. So you're going to say, yes, he had intercourse with her, but did she give consent? You're not going to look at what is consent and whether she gave consent, and you're going to realize, oh no, she never said she's going to, she never agreed to do this with him in any way, shape, or form. And so in applying your principles to your facts, you're going to say, well, she didn't give consent and there was intercourse. You're going to look at whether there was penetration, and in you assessing that, yes, he used his body, and you can infer that. So in your application, you're going to say that you're inferring that he used his body because the facts did not tell you that he used anything. And this is another thing I want to tell you guys for your exam. Please do not go in there putting anything that is not in the question. If the question said he had intercourse with her, it did not tell you that he used anything on her body. So please do not put that in the question. Just put what you see there. It says he had intercourse with her, and you're going to infer, or you can put in your analysis that I infer that he's using his body part, and the fact that he used his body part, the fact that she did not give him any express consent, and the fact that so the fact that he had intercourse with her, he used his body part, he used his he used his body part, he had sex with her, and she did not give any express consent, then it is rape. He can be liable for rape. Or you can put, since you haven't concluded the question, that there's a strong possibility that he will be liable for rape, and that is your conclusion. That is the issue, rule, analysis, conclusion. As easy as that. Anybody has any questions? You could speak to grievous sexual assault, being section 4, if penetration was not with his body part, but I just think that's going to cause extra words and extra work, especially because it did not ask you for that and you're only getting 15 marks for it. So if you want to put it in, I'm sure A++ students, yes, you could put it in, but please do not go too in-depth. So what you really need to focus on is section 3 as to what is rape, and section 2, which explains what is penetration. And you can use the case of Tamaki and the Queen. And what happened here is that K penetrated V, believing that she consented. During intercourse, he discovered that she did not consent, but continued the intercourse nonetheless. He was convicted of rape and an appeal. His appeal was dismissed as the Privy Council dismissing the point, argued that the appellant that the meaning of the word dismissing the point argued for the appellant as to the meaning of the word complete. The applicable statutory provision contains a provision that sexual intercourse is complete upon penetration. Now, what was the problem in Tamaki, even though he spoke about consent, was that they weren't focusing too much on the consent. He was focusing on the penetration as to whether it was complete. Now, the court was saying that complete is used in the statutory definition in the sense of having come into existence, but not in the sense of being at the end. And sexual intercourse is a continuing act which only ends with withdrawal. And what basically was happening in this case was that they were saying that penetration, it doesn't matter how slight, it is considered rape. So again, for that first issue, because you guys don't have the slides, I want to kind of repeat, so I hope that is fine. And the issue is whether Scott's act of having sexual intercourse with Marie after the initial dismissal of her advances is enough for him to be held liable for rape. Again, you look at section 3 of the Sexual Offences Act. You look at section 2 for the definition of penetration. You look at section 4, which talks about sexual grievous sexual assault, but again, you don't pay too much attention to that. And you look at the case which I just gave you, but there are other cases. But I'm just giving you this one, Kate and Markey and the Queen, which you can look to. And you can use that case to, how that case is used to assess what is considered penetration as well. And you use that, and after that, you can apply to the facts here. Once you apply to the facts here to say that, well, one, he did do it without her consent, he did use his body part, and that is what is used to constitute rape. And you put in conclusion, he may be liable for rape. Then you move to the second issue, which is whether the fact that she did not make a sound, whether that constitutes or that shows that she consents to rape. Because if she consents to rape, then he would probably be charged for something else, but it wouldn't be rape. If she consented to having intercourse with him, then he would be charged for something else, probably, sexual assault or sexual harassment, but probably not rape, because once you consent to sexual intercourse, it's not rape. And we would have seen that from section 3. So again, whether the fact that she was silent indicates that she gives consent. What is consent? As I had said to you guys before, when you're giving your principle or when you're giving your rule, you can give a brief definition of the key term. So you could give me 1 second. All right, so consent is all right, so Marisha said something here. He commits the offense of rape if he penetrates without consent permission. He penetrated her after threatening her. He did not have the complete act of sex. Does not matter now if she is a wife or not, because of the law that says that a wife was deemed to have consented irrevocably, to sexual intercourse with her husband, and the husband can be convicted for the crime of rape. DPP and Morgan. All right, thank you, Marisha. But we are on the second issue, and that is the third issue about whether she's his wife. So we'll get to that eventually, but we're now focusing on the second issue, which is whether the fact that she was quiet was consent that he could rely on. And the principle that we are going to, or where we'll infer, or where we'll get the principle in terms of that issue is from, I think it was Joseph who said it before, which is R and Oluboja. And in this case, L raped V, then took her companion K into an adjoining room, intending to rape her. L's companion O told K that he was going to have intercourse with her and told her to remove her trousers, which she did out of fear. She did not struggle or resist O when he had intercourse with her. O's appeal against conviction was dismissed by the Court of Appeal. Don LJ said he was talking about the jury should be directed to concentrate on the state of mind of the victim immediately before the act of sexual intercourse, having regard to all the relevant circumstances, and in particular, the events leading up to the act and her reaction to them, showing the impact on her mind. Apparent acquiescence after penetration does not necessarily involve consent, which must have occurred before the act takes place. So to that end, I think in your analysis, you will know what to do. So in your analysis, you can now look at the fact of what was her state of mind before he actually slept with her. So first, you would have seen one where he tried to kiss her. So in applying the rule to your facts, you would have seen where he tried to kiss her and she said no, right? She pushed him off. And then he forced himself on her and he said he was going to rape her, right? You can assume he also held her down. So you can assume that on these facts, she was fearful. She was in shock. And the facts of the case said that she was in shock. She didn't know what to do. And out of fear, she allowed him to rape her. She did not, she allowed him rather to have sexual intercourse with her. She did not consent to the act because it was out of fear. And also you can see where she already did not consent to him making any form of sexual advances to her, because she did push him off initially. And then when he forced himself on her, when he told her he was going to rape her, she was in shock. And that's why she allowed him to do it. But it was not a willing thing. It's not like, oh, she went there to sleep with him. She went there to study. And he forced himself on her. And she told him no initially when she made the advances to kiss her. And then he forced himself on her and had intercourse with her. And out of shock, she allowed it to happen. But it's not consent. So that's how you would apply your rule. And your rule is coming. You remember when I told you that the rule comes from statutes, but it also comes from case law. And so your rule that you would use is R and Olugboja. And then in conclusion, you would conclude that silence is not consent. And looking at Marie's state of mind before the activity took place, you can see that she did not consent to the intercourse. And so it remains on the face that his actions of having intercourse with her constitute rape. All right, so the final issue that we will look at under this question and under criminal law overall is whether he would have been convicted of rape if she had been his wife. And we know that there is a lot of problems, especially when you think of R&R, which I think was the deal breaker case. We know that there have always been a lot of issues with marital rape, and we would have spoken about it was module 1. We spoke about in module 1 natural law and how natural law applies to our legal systems. Now, the problem is that, the Bible, natural law, the belief that natural law is in our legal systems it's inferring from the Bible. And that belief coming from biblical days until now is that a man cannot rape his wife, right? And you would have seen cases, or you would have heard things which speaks about, unfortunately, the wife being the property of the man, and a man can't rape his wife, or especially this one that says the man and his wife are one, and you can't rape yourself. So you would have seen or known that it would have been an issue coming from those times as to whether a man could rape his wife. But the case of R&R is where things would have changed. Give me 1 second, please. All right, sorry about that. Yes, so the position of R and R is where it is changed, and in your principle is where you get into the explanation to say that before R and R, so you would have to make it known that before R and R, a man could not rape his wife unless there are certain circumstances. These circumstances including that they are no longer together or they're no longer cohabitating. So you have to make note of that they no longer cohabitate, and this is our grant of a decree nisi, which means that the court have allowed for the divorce, or the marriage has broken down and they're no longer together, and they have a formal separation agreement. So they must not be cohabitating because of the order of the court. They must be formally or legally separated, or they must be divorced. So those are those would have been the exceptions before R and R for a man to be able to rape his wife. But R and R would have changed that, because in this case, the court rule that a man can rape his wife on certain basis. So in this case, the defendant was married to his wife, and Joseph yes, I'm saying R and R is where it was held that a man can be criminally liable. Yes. R and R is where it was held that a man can be criminally liable for raping his wife. Yes, R and R. All right, so in this case, basically the couple had separated, and they had no formal legal separation, but and none of the parties had petitioned for a divorce. However, for some time the marriage had broken down. So there was no indication of them being a couple that was, how would I say, being a loving married couple. The marriage had broken down and they had separated. So even though they didn't take it to the court, they had separated. So initially, before R and R, you remember I said that, that's why I said you have to put in your principle that before R and R, the only three ways that a man could rape his wife is by legal separation or formal separation, if they're not cohabitating, or if they're divorced. Because what had happened in this case was that they were not legally separated and they were not divorced, but they were separated. So originally in the lower courts, they were saying that because you're not formally separated, or because you're not legally separated, or because you're not divorced, then the man cannot rape his wife. However, in R and R is where the court moved away from the initial position to say how you have to be legally separated for you to be charged for rape. So you can be charged for marital rape as long as it fits all the other requirements for rape, which again would be section 3 and section 3 and section 2, which speaks to penetration. There are also some jurisdictions which will put in their laws, in their Sexual Offences Act, to say that rape is rape. So whether you commit it in the context of marriage, or whether you commit it outside, or whether you can commit it inside of marriage or with a stranger, it is still rape. And another principle that you can rely on in the context of Jamaica is our Sexual Offences Act. And it is in section 5, which says that a man can rape his wife, but it does give circumstances in which this can happen. And so the husband commits the offense of rape against his wife if he has sexual intercourse with his wife is in any of these circumstances. If he does it without her consent, if he does it knowing that she does not consent to sexual intercourse or recklessly not caring whether she consents or not, if he did it with the use of physical assault or threats to hurt her, if he I think another one is if he knew that he had some form of disease or something, and he had sex with her without telling her that he had this disease. All right, basically, so yes, if he's suffering from a sexually transmitted infection, then he will be liable for marital rape. So again, it is, I think it's a wide range of stuff, but section 5. So you can look at section 5 of Jamaica's Offences Against the Persons Act, and you can use R&R as your principle. And so in applying section 5 and R&R, then to the facts of the case, or to the facts of the issues, or to the facts of the issue presented to you, your answer would not have been different. Or well, let me not say, because I can't answer for you, but my answer would not have been different to say he would have still been liable for rape, whether or not she was his wife, because she did not give him consent, he had intercourse with her, he used his body part, and even though she was quiet, it was still no consent, especially because she would have pushed him off before when he made the sexual advances, and she did it out of shock, so she was scared. And so in conclusion, whether even though he is her husband, he would still be liable for rape, because since R&R, a man can now rape his wife, and this is contained in section 5 of the Sexual Offences Act of Jamaica. So he would still be liable for rape. And then after you make that last conclusion to that issue, you would, the question, let me go back to the question, sorry. The question said that you should advise Scott on whether he would. So after you answer all your issues and you put all your mini conclusions and you put your rules and your application, then you would conclude with the big conclusion in the end to say, in conclusion, in advising Mark, he would be liable for he would be convicted, or he will be convicted for rape, given that he had sexual intercourse with Marie without her consent, and also it does not matter whether or not she was his wife. And that would be your general conclusion. Any questions? Let me check the chat. Okay. Any questions? Any questions overall about, because this is the end of it. This is the end of the session. I actually went over the 3 hours by 35 minutes. I'm so sorry, guys. Any questions in general? Module 1, module 2, module 3, anything that you want to know that, or anything you'd want some information on, any topics you have any problems on that I could probably send later on in the group, because I did ask and I didn't get a lot from you guys. So is it that you guys are fully ready for the next 2 weeks? Super brilliant children who are going to do well. I do believe in you. But if you have any questions, now is the time to speak, or forever hold your peace.
Miss, the book you told us that you might send for us later?
Yes, Rosemary Bellantoine.
Yes,
she speaks to Commonwealth Caribbean law and legal systems.
yes, ma'am. Thanks.
Okay. All right, I'll send that right now. All right, so if that is it, it was good being here with you guys, and I do wish you all the best for your exams, and I hope to see you again for paper one. And I think paper one is in June. Yes, I will be doing a session for unit 2 as well, Joseph. You can just look on NJF's Instagram page, and you should be able to see when unit 2 session will be. You're welcome. Have a good night, everyone. Okay, so I missed just someone asking about inchoate offenses. All right, I can do so, but it wouldn't be until about Tuesday, Tracy, and if that's fine. Is that okay? Tracy? Tracy?